Hello, this is Matt on the Moon Family Sedan channel. Attorney John Deaton shared a huge victory which occurred in court today. And you better believe it's certainly going to have an impact in the SEC v. Ripple case as well. You better believe that Judge Annalisa Torres is definitely going to be aware of this ruling that occurred having to do with the remedies portion of the SEC v. Library case. Now, of course, a couple months back, the SEC did win in court, so yes, Library lost, but it doesn't mean that the actual entire case is over. We're at the remedies portion where penalties, so on and so forth, would be assigned, and something gigantic is at stake. And technically it still is, but I think we know at this point how this is going to go, thanks to news shared by Attorney John Deaton, and thanks to his efforts, quite frankly. Because the question is, even though Library was found in the SEC v. Library case to have sold unregistered securities, and of course I dispute that, but anyway, that's the case. Even though that was found to be the case, there's still this question of what about transactions in secondary markets, which is a gigantic issue in the SEC v. Ripple case. Because what, is it the entire ecosystem that constitutes some sort of common enterprise? Does that mean that you and I are in a common enterprise? And if the SEC wins in the Ripple case, then you and we can't lawfully transact and send XRP back and forth to one another? And that's what's at stake here. Because frankly, and this is kind of I'm hoping for an outright win regarding the Ripple case, but even if Ripple loses, there could still be a path forward where secondary markets are continued to allow to exist. And what's crucial is that it's found by the judge, of course, it's understood that it's not the XRP token itself that is the security. So in this in court today, the judge articulated such that when he writes his final judgment, one thing what he said today, and we'll see how he words it, but he did write today, he did state today in court that secondary market transactions obviously not covered by his ruling. That's huge news. That's absolutely gigantic news. And the judge got the SEC to agree to that. So the SEC is on record in court agreeing with that assessment. Very cool stuff. So, but before giving you the additional specifics and so on and so forth, I do want to be clear, I do not have a legal or financial background of any kind. I'm not offering legal or financial advice, and you definitely should not buy or sell anything because of anything I say, right? I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. All right, so yesterday, January 29th, there were a couple tweets shared by Attorney Lewis Cohen. Now, Attorney Lewis Cohen wrote... I can't remember the full name of this piece, but it was an over 100-page piece, and he painstakingly went through all of the case law dating back, I believe, to 76 years to find that on record, there's literally no case ever that finds that the underlying asset itself is the security. And so he prepared this himself. I can only imagine the amount of work that this took, gigantic document, and then handed it over to the judge in the Ripple case, as well as to the judge in the Library case. And it's very telling, and the judges should be aware of this. And so Attorney Lewis Cohen is the one that wrote the following. This is again yesterday, before we got the good news today. So yesterday he wrote, so as some may know, tomorrow is a big day for Library and the entire crypto community. The judge in SEC v. Library Inc. will hear oral arguments on the application of remedies. An amicus brief from Attorney John Deaton and local counsel is here. Please have a look. And then he shared a link to that. And then he said, at stake is whether a judge buys the argument that a crypto asset, basically a number, that allows the owner to send instructions to a network, can somehow embody an investment scheme by a company that is about to dissolve. Watch this space. And then there's somebody named Pyrus, not familiar with this individual, doesn't matter, but seems to not have a clue as to, case precedent or anything having to do with securities laws, and is disagreeing with Attorney Lewis Cohen. So this individual Pyrus wrote to him and said, this brief is 100% red herring, e.g., additionally, quote, additionally, considering that Brockwell was unaware of the monetary value associated with LBC, she could not have had a reasonable expectation of profits, end quote. So it's not a security if one person didn't know it had value? Absurd. So this person's not buying things. So just because one person didn't know that it had an open market value, that means it's not a security, and that person thinks that's absurd. But again, this individual, nothing against them, I don't know who it is, they do not know what they're talking about. And Attorney Deaton jumped in to kind of set the record straight here. He said, the underlying asset in an investment contract is not the security. Any asset can be offered and sold as an investment contract. Bitcoin has, but that didn't turn Bitcoin into a security. Beavers have been sold as securities. They remain beavers. LBC is not a security. It's code. And then Attorney Lewis Cohen jumped in to back up Deaton there, and he said, yep, the relevant question at any given time is whether the LBC token is being sold in an investment contract transaction. Is the seller at the time of the sale inducing the buyer to purchase from her by making undertakings to the buyer about the profit potential of the asset? Exactly. And then Attorney Deaton expanded upon that and wrote, the application of Howey is not that difficult to analyze. Those involved in crypto litigation and regulatory policy must get judges and United States regulators/legislators to stop focusing on the token itself. The token itself is actually somewhat irrelevant to the Howey analysis. Hester Peirce herself has criticized her colleagues at the SEC for focusing too much on the token itself. Watch her be interviewed by Tony from Thinking Crypto YouTube channel below and go to the 18-minute 58-second time mark in the video. A sitting commissioner of the SEC made the point that Attorney Lewis Cohen is making. She said, quote, we tend at the SEC to talk about the token itself as a security, and that's really a shorthand. What we've done now is said that orange groves are kind of like the security, end quote. And so look at, like, that's the culture of thought at the SEC. Hester Peirce is giving you inside info right there that we would otherwise not be privy to. That is the way that they're thinking about it. And this is completely out of line with case law, and you can see it in the way that the SEC has brought enforcement actions against entities in the world of crypto. It's the asset itself. And so even though they know that's not something that's not actually a winning argument, they still push it, but they have to kind of walk a fine line. You'll see as we go further, because I'm going to expand upon that in this video. Here's what Attorney Hogan had to say, and this was just this morning, I believe. Yeah, there we go, 10:28 a.m., January 30th. So this was hours before the hearing got underway in New Hampshire. And Attorney John Deaton, again, just to be clear, I'm not sure if I stated it clearly enough at the outset of the video, Attorney John Deaton was there and did speak directly with the judge. But anyway, hours before the hearing, Attorney Hogan wrote the following. Today is the remedies hearing in the SEC v. Library case. The SEC wants the judge to issue a broad, vague injunction against the sale of the library token in which the token itself becomes the security. Attorney Deaton will be attending live and report back at 6 p.m. Eastern on crypto law. Note the problematic language in the SEC's proposed order. Quote, and this is what the SEC is arguing, because and mind you, they're looking for a permanent injunction to prevent any of these transactions that have been deemed to be violations from ever happening again. So look at the problematic language as Attorney Hogan cites. It says, quote, all persons in active concert or participation with it, end quote. And Attorney Hogan then says, that would be me and you. I've never heard of an injunction applying to individuals who are not a party to a lawsuit. But that's what the SEC wants. And he shared this screen grab. I'll blow it up for if you want to read the whole thing here. But that is what they're stating here. The SEC wants everybody that transacts the token for them to not be allowed to do it anymore. That, talk about overreach. That's incredible. And so then somebody named Crypto Cannigan responded to Attorney Hogan and said, how does the SEC argue library token is a security of a company that no longer exists? And so I'll pause to note in case you hadn't heard, Jeremy Coffin, the founder, has indicated that it's as close to 100% certain as possible that library itself, the company, not the token, but the company is going to cease to exist as a result of all of this. And so Attorney Hogan responds and says, they don't dare. So instead, they ask for a permanent injunction that includes every person who would sell the token. It's a backdoor. So again, this goes back, again, because their culture of thought at the SEC, which is disgusting, is that the asset itself is the security. And so they don't dare argue that it's a security of a company that no longer exists, because again, library is about to no longer exist. And Attorney Hogan says they don't dare argue that. So instead, they want this injunction. That's what they're going for, so that all transactions would be included in that injunction, including stuff for me and you if we had LBC and we wanted to transact it. So he's saying that's a back door. That's how they're getting about it. They're walking this kind of fine line where they're not outright making the claim technically that it's a security of a defunct company, but if they get the ruling that they're asking for, then it might as well be. That's the fine line that they're walking. So you can see how they're doing the sneaky thing that would just absolutely destroy regular investors. And not just investors, but users of the library credit token. And then there was also this. Somebody named Fenris Ulven wrote to Jeremy Hogan and said, I don't really understand how the SEC is going to apply this to foreigners. It doesn't seem like people from other countries are excluded. Attorney Hogan wrote back and said, well, if the token itself is a security under U.S. law and you sell it to me, then you've sold an unregistered security to me unlawfully, unless there's an exemption. Yeah, so that would undoubtedly be true. I guess at that point, it's kind of like a question of, if you do the unlawful thing and you're in a different country, to what degree is the United States going to work with the foreign nation to enforce some sort of penalty on an individual that does such a thing? And maybe if it were big enough transactions in terms of dollars caught enough attention, maybe something would happen. But I think the truth is that there's so many actions, transactions that take place. In reality, I don't know that they could really reasonably enforce all of that, or even most of it necessarily. But I don't know how many people, after this goes down, if it goes down really, truly negatively, would still try and use the tokens. We'll see. If we hopefully we won't see. Actually, hope we don't get to that point here. And so then there was this, excuse me, from Attorney John Deaton. This is today in the afternoon. He said, just finished speaking on the record with the judge in court. Court is not over. Check in at 6 p.m. The judge and I talked about Attorney Louis Cohen's article, and he forced the SEC to commit on the record. And that's incredible. And I actually took some notes because I'm going to go through it in just a second here, but I listened to what Attorney Deaton had to say last night, or in the evening, whatever. And then 1 second here. Actually, let me just leave it there here. So anyway, I actually did, like I said, type some notes. So you're hearing this one sheet of dead tree in my hand right here. And he noted there actually, it seemed like a lot of people there, relatively speaking, 50 to 60 people actually in the courtroom. So it's a public hearing. There just wasn't, like you see in the Ripple case, there wasn't a number to call in, so we couldn't just call in and listen, or else I'm sure all sorts of us would have done that. But it was open to the public. It's just you have to go to New Hampshire. So if you're not anywhere near that, probably not convenient, especially if you're on the West Coast. You're going to fly out there? But anyway, so the judge's decision in the library case did not address secondary market sales, which is why John filed an amicus brief in the first place this past December. So again, John Deaton, he filed the amicus brief after library actually lost, because it wasn't clear what that meant for market participants, secondary markets. And so he represented somebody named Naomi Brockwell, who has never bought or sold any library credits ever, but does hold them. And so then Attorney Deaton, he isn't taking a position on any fines that library may have to pay. He's literally just there to represent Naomi Brockwell, because this decision will impact all secondary market participants. And Attorney Deaton told the judge that his decision reads as though the underlying asset itself, LBC, is a security. And if the judge's intention is not to communicate that LBC itself is a security, then we need to address and clarify the situation. And that's literally what Attorney Deaton told the judge, undoubtedly very respectfully, in court, though. And having read the final ruling and shared it on this channel, yeah, it wasn't good. It definitely was not good. And the judge told Attorney Deaton that he will not be issuing an injunction that would impact participants in secondary markets. So that's fantastic. That is big news. That they're not going to issue any sort of injunction that would impact participants that were not a part of the transactions that were found to be in violation. That's very good news. And Attorney Deaton got the SEC attorneys on record to acknowledge that even though LBC sold by library to a business is a securities violation, that's been determined, if the receiving party then sells their LBC to a third party, in that case, the judge's order would not apply to the sale. And so that's why Attorney Deaton says that's a major victory. And he's absolutely correct right there. The only way that there could possibly be an exception, and this is the route that the SEC asshat attorneys try to go first as well. It could still be a violation because if they're an agent that happened to be party to this or somehow, but then ultimately the judge pressed him. As that's what Attorney Deaton stated. The judge pressed the SEC on this, and they acknowledge that if it's somebody that's not specifically cited to be a party in this case, like it's not library, well then it's clearly not part of this ruling. Now moving forward, that's absolutely gigantic news because we know that that's what's true. But for the SEC asshat attorney pricks who are basically doing really slimy stuff because they want it to be the case that the asset itself is a security, this is a blow to them because this is the judge effectively saying no. And the judge said that although there was not enough evidence to support library's fair notice defense, that we shouldn't pretend that there is perfect clarity surrounding the crypto asset class, especially in a case like this one where there was no initial coin offer. And I found that to be very telling because what does everybody at the SEC say from Kim Jong-Gensler on down? Oh, but everything's perfectly clear, very, very clear. Well, even the judge here, who said that there wasn't enough evidence from a technical perspective for library's fair notice defense, even he says, yeah, you really need to have more clarity. So even the judge said that, and the judge ruled in favor of the SEC. That's amazing. That is absolutely astonishing. And the judge says that he intends to include language in his remedy decision indicating that secondary market sales are not included in his ruling against library. And the judge asked Attorney Deaton if that would satisfy him. And Attorney Deaton then suggested language be included, stating that the token itself is not a security, but the judge rejected that, stating that he is a minimalist. So I appreciate that Attorney Deaton pushed for that because that would make it completely unquestionable what the state of things here is. But even without that, I think it's still clear because look, if you think about it, if the token itself were a security, that would mean that every time it's sold by anyone, that would be an illegal transaction. The fact that the judge is saying secondary market sales are not included in his decision means the token itself could not possibly be a security. It logically follows that it could not be. And Attorney Deaton pointed that out in the evening when he did his live stream. And, it's also unfortunate, and Attorney Deaton pointed this out, none of this would be necessary if we just got instead clarity from Congress, but he pointed out, and I think he's right, unless we get clarity from Congress ASAP, this is going to be it's going to be like the rules of the road effectively for potentially years. Because, again, outside of getting something from Congress, and I don't think we're going to get some sort of clarity from the SEC, what else is there? That's why this is such a big deal. Like, this is really, truly to the positive. This is fantastic. The SEC cited the library case 20 times in the Ripple lawsuit since the SEC had a clear victory there. And if indeed the judge does what he says he's going to do, and writes the secondary market sales are not in violation of securities laws, that fact could be shared with Judge Torres in the Ripple case. So that could be a very possible result from the positive result from the library case for XRP holders. So this is highly consequential. That's why I've been focusing on this for weeks. I've been mentioning it on and off on my channel. It's a big deal. It's a really big deal. And so should exchanges relist the LBC token? Attorney Deaton was asked that during the live stream. And, yes, this should be a ruling. Of course, technically we need to see the judge write the damn ruling first. But yes, this should be a ruling to give exchanges confidence to relist LBC. But Deaton says, it's hard to predict, and there may be some exchanges that are very conservative and are not convinced the judge's comments on secondary market sales are clear enough. So it will also depend on the specific wording of the judge's ruling. So we're going to have to wait on that, and as soon as we get it, I'll be happy to talk about it on my channel here. But this is really positive. If you have something like this happen in the SEC v. Ripple case, even if Ripple loses, it's highly likely there's still a path forward for XRP to continue to exist and be used in the United States. So I don't know what that would mean for XRP being adopted as a bridge currency via on-demand liquidity. It depends on, because there's a number of ways things can kind of fall, but this is good. It's good that this happened, and again, Judge Torres in the Ripple lawsuit is going to see this, and so she's going to have to make the first move along these lines. Another judge already did that, so We'll be watching here. Let me know what you think in the comment section below. I'm done. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the Moon Family Sedan.